Hello everyone, I hope you're having a good day and you're staying safe. I'm Sesa Gill, a legal intern at LEXIS and Company, and today I'm going to be talking about nuisance as a tort. So first of all, let's talk about what is a tort. The term tort is a French equivalent of the word wrong, and the word tort is derived from a Latin word tortum, which means twisted or crooked or wrong. And so, in simple words, a tort is a common law jurisdiction, which is a civil wrong, and that causes a compliant to suffer loss or harm, resulting in legal liability of a person who commits a tortious act. Now let's talk about nuisance as a tort. Nuisance is a legal action to redress harm arising from the use of one's property. Now, the word nuisance is derived from a French word called nuire, and which means to hurt or to annoy. Now, one in possession of property is entitled as per law to undisturbed enjoyment of it. Now, if someone's improper use of his property results into an unlawful interference of his enjoyment of that property or connection with it, we must say that that is nuisance. Now, in other words, nuisance is an unlawful interference with a person's use or enjoyment of land or a connection with it. Nuisance is an injury to a person's right in possession of a property to undisturbed use of it, and a result of improper use by another in his property. Now, let's talk about what are essentials of a nuisance. In order that nuisance is actionable tort, there are some essentials that exist. So first of all, it is a wrongful act, and second is damage or loss or inconvenience or annoyance caused to another. Okay. There are two types. There are two kinds of nuisance. First is public nuisance, and second is private nuisance. So let's talk about public nuisance first. Section 128 of the Indian Penal Code defines nuisance as an act or illegal omission which causes any common injury, damage, or annoyance to the person in general who dwell or occupy property in the vacancy, or which may necessarily cause injury, danger, or annoyance to a person who may occupy to use any public right. In simple words, let's talk about it. Public nuisance is an act affecting the public at large. Now, some considerable amount, and it must interfere with rights which member of a community must otherwise enjoy, which means that public nuisance should be it's at public at large, and it can only be effective when it's hampering the rights which others are already enjoying. Now let's talk about private nuisance. Private nuisance is using or authorizing the use of one's property or of under one's control by physically injuring his property or affecting its enjoyment by interfering materially with his mental comfort or with his health, comfort, or convenience. Now, elements of private nuisance: unreasonable or unlawful interference. Secondly, such interference is with the use or enjoyment of land, or in some connection with the land. And third is damage. Now, kinds of private nuisance. Firstly is damage to property. In the case of damage of property, any sensible injury will be sufficient to support an action. Now, there is Secondly, physical discomfort. In case of physical discomfort, the two following conditions should be filled. Firstly, in access to natural or ordinary course of enjoyment of the property, and secondly, material interference with the ordinary comfort of the human's existence. Now we're going to talk about the defenses to nuisance. First is prescription, and a title acquired by use or time allowed by law. When a man claims anything because his ancestors or whose estates he helped have had possession for the period prescribed by law. Now we're going to talk about the other defenses to nuisance, which is statutory authority, where a statute has authorized the doing of a particular act or the use of land in particular way. All remedies, whether be use or action, are taken away, provided that every reasonable prescription constitute with the exercise of statutory power has been taken. Statutory authority may either be absolute or conditional. Now there are three remedies to nuisance. First is injury. First is injunction. Then there is damages, and then there is abundance. Now, in conclusion, I would like to say the law of nuisance is almost an uncodified one. Yet it has grown and expanded through interpretation and just judgments that have been taking place. The concept of nuisance is that arises most commonly in a man's daily life, and decisions regarding the same have been delivered on case-to-case basis, ensuring that neither the aggravated plaintiff goes through these damages, nor the defendant is punished unnecessarily. So thank you so much for being here. Do subscribe to the channel, and thank you so much.